Greetings legal minds, and welcome once again to the lecture hall brought to you by Emmy's Legal Nugget. Today we would try to examine a particular offense in Nigeria as provided for in the Nigerian Criminal Code, which is the receiving and the unlawful possession of stolen property. While we should understand that theft, stealing, robbery, and other kind of offenses are acts which comes with a measure of punishment. Merely receiving a property or having a possession of a property which you know is stolen also comes with another measure of punishment. And for the purpose of this tutorial session, we will try to examine the major elements that must be established for this offense to be proven against an accused in relation to the provisions of the Nigerian Criminal Code, which is the principal legislation governing criminal activities in southern Nigeria. Firstly, according to the express provisions of Section 427 of the Nigerian Criminal Code, a person who receives a property which was obtained illegally or stolen is liable to imprisonment for 14 years if such property was obtained by a means which is a felony according to the law. But if such property was not obtained by a means which is a felony, such individual would only be liable to imprisonment for 7 years. Now, coming to the major purpose of this lecture, while we've understood that a person would be liable for punishment for receiving a property which was obtained illegally or was stolen, we must, however, note the essential elements that must be proven by the prosecution to make the accused liable for punishment for this particular offense, as without a proper understanding of the different elements, it will be very difficult to determine whether or not there is actually an offense of receiving property which was obtained illegally or was stolen in different and special circumstances. On a close examination of Section 427 of the Criminal Code, as we already cited, which is also similar to the provisions of Section 317 of the Penal Code, which is the principal legislation governing criminal activities in the northern part of Nigeria, there are certain elements that must be proven and established before this offense can be said to have been committed by a competent court of law. For the offense of the unlawful possession or receiving of stolen property to be properly established, the prosecution must prove that the accused have the knowledge that the property was stolen. It must also prove to the court that the accused also had an intention of possessing a property knowing it to be obtained illegally. Thirdly, it must also prove that at the time of arrest or investigation, the property was found within the reach or in the possession of the accused. So, without a proper proof of these different elements, it will be very difficult to ascertain as to whether or not the offense of receiving or the unlawful possession of stolen property was actually committed. Note that the law doesn't just frown at the offense of stealing, robbery, or theft. It is also clearly against the offering of aid to a person who engages in stealing. And one of the major ways the law does this is by the express criminalization of the act of receiving stolen property or having in possession of property which you know that was stolen. To get the criminal code and the penal code for reference purposes, you send us a private message and such will be acknowledged when received. Thank you so much for your time. Do follow us and subscribe to this channel to be updated when more insightful nuggets and legal tips are sent.